Role of injunction. As a general rule, labor disputes are not subject to injunction. However, the protective force of a law will be applied when prohibited or unlawful acts are being or about to be committed that will cause grave or irreparable damage to the complaining party. Requirements of valid injunction. Article 218. These are those requirements of valid injunction. Unlawful are being Number 1, unlawful are being committed or threatened to be committed. Number 2, the act, if not enjoined or if not performed forthwith, may cause grave or irreparable damage. Witnesses must be heard or opportunity for cross-examination provided. Number 4, the complaints if made under oath. Number 5, as to each item of relief, the injury to the complainant will be greater by its denial than to defendant by its grant. Number 6, complainant has no adequate remedy at law. Number 7, public officers are unwilling or unable to do their duty to adequately protect complainant's property. Temporary restraining order. The code allows the issuance of temporary restraining order without prior notice to other parties concerned. The issue is predicated on complainant testimony or petition under oath that unless the order is issued without notice, substantial or irreparable injury to complainant's property will be unavoidable. A temporary restraining order, however, automatically expires after 20 days. Jurisdiction to issue injunction lies not with regular courts but with the Commission, with Maria Cristina Fertilizing Plant, ESSN Tanjang. However, regular courts may be issue injunction if it is to prevent strike from preventing to lawful movement or third parties. Injunction in national interest cases. When a strike enjoined by the assumption of jurisdiction of the President of the Secretary of Labor and Employment, a strike of lockout is prohibited after assumption of jurisdiction by the President or the Secretary of Labor. Number 1, in industries indispensable to the national interest, or after certification or submission of the dispute, the compulsory or voluntary arbitration. In R 264, the code vests the President and the Secretary of Labor almost unlimited discretion as to what industries may be considered indispensable to national interest. Power to assume jurisdiction constitutional. In Article 263 and 264 have been enacted pursuant to the police power to the state. If it is an inherent power of the state which does not need to be expressly conferred by the Constitution. Certification of labor dispute, automatic injunction. Such assumptions of the Secretary of Certification to the NLRC for compulsory arbitrations has the effect of automatically enjoining the intended or ongoing strike or lockout as specified in the assumption of certification order. The assumption of certification order is immediately effective even without a return to work order. As a strike that is undertaken despite the issuance by the Secretary of Labor of an assumption or certification order becomes a prohibited activity and thus illegal. Not only union officers but only union members who define return to work order are subject to dismissal for participation in a legal act. Effect of certification for compulsory arbitration. The certification of compulsory arbitration overrides under the unresolved proceedings before the NLRC. Proceeding in the injunctions and unfair labor practice case filed by the ER necessarily have to be suspended to await the outcomes of the compulsory arbitration proceedings. Incidental issue. May the Secretary of Labor, in the exercise of the injunction under Article 263, takes cognizance which is merely incidental to the labor disputes over which he has assumed jurisdiction? Yes, provided said issue involved in the labor disputes itself or otherwise submitted to him for dissolution. Agreements of the parties. Number 1. A no strike prohibition is a CBA is applicable only to economic strikes. An unfair labor practice strike is not covered, and workers may go on strike based on the unfair labor practice despite the no strike provision. Number 2 is no strike clause binding on the newly certified or bargaining agent. No, this is a personal undertaking of the old certified bargaining against which does not bind the newly certified bargaining agent. There is no violation by the union of the no strike clause if the works stoppage was not initiated or supported by the union. About 1,400 EES of a company staged a mass walkout. The strike was staged without prior notice and in violations of the no strike clause. It is not, however, disputed that the company did not pay the salaries of the EES for 2 months. In the exercise of his power of a compulsory arbitration, may the Secretary of the Labor declares the strike illegal. Even the assumptions that illegality of the strike is predicated on the violation of the lack of notice of strike and the no strike clause, is still the automatic finding of the illegality of a strike finds no authoritative supports in the light of attending circumstances. Employment of a strike breakers and role of peace of officers during strikes. In Article 264, number 1, no ER shall use or employ any strike breaker, not shall any person be employed as a strike breaker. Number 2, no public official or EE, including officers and personnel of the EFP, of the PNP, or armed person shall bring in interest of escort any individual who seeks to replace strikers in entering or leaving the premises of a strike or work in place of strikers. The police force shall keep out of the picket lines unless actual violence of the other criminal acts occurs. offer bulleting. What it means by improve of reduce after bulleting. Balloting. Strike. In an effort to settle a strike, the dole shall conducted of a referendum by secret balloting on the improved offer of the ER or before the 30 day of the strike. When at least a majority of a union members vote the accept that the improved after the striking workers shall immediately return to the work and the ER shall thereupon remit them upon signing of the agreement. Lockout. In case of lockout, the dole shall also conduct of a referendum by secret balloting on the reduced after the union on before the 30 days of the lockout. When at least of majority of the board of directions of the trustees of the partners holding the controlling interest in the case of partnership vote to the concept the reduced after the workers shall immediately return to work and the ER shall thereupon readmit them upon signing of the agreements in Article 265.
Good morning everyone, I am Ray Mardado, one of the reporter of Union Concerted Activities. My topic we are going to tackle to you, things slow down in other concerted activities. Picketing is walking or patrolling in the visiting of a place of business involved in a labor dispute in by the words of mouth, banner or placard. Undertaking to inform the public concerning the dispute. Picket is a form of protest in which people called pickets or picketers congregate outside a place of work or local where an event is taking place. Next, picketing and labor law. The mere fact that the language employed by the picketers is performed being courteous and polite does not giving rise to accuse for leaving and damage. And employers and employee relationship absent of employer or employees relationship does not make picketing illegal. Employers and employer relationship is the interplay of the necessary process of maintaining relationship as and picketing. Peaceful picketing is entitled to protect as an exercise of free speech. Courts are not without power to confine or localize the sphere of communication or the demonstration to the parties to the labor dispute. Include those with related interests and to lead establishment or person with no industrial connection of having interest total foreign to the context of the dispute. Slowdown is a method by which one employees without seeking a complete stoppage of work in an effort to compel compliance by the employer with the labor demand made upon by him. For example, if the employee make 10 boxes a day and next day drop to 5 boxes, all he can do is called slowdown. Next, boycott. Boycott So it is the concerted refusal to patronize an employer, goods and service, and to persuade other to alike refusal. Like po sa ginawa ng mga media kay Duterte, yun po ay tinatawag na boycott. A mere participation of a worker in a lower strike shall not constitute sufficient ground for termination of his employment, even if a replacement have been hired by the employer during such lawful strike. However, if the strike is illegal, 1. The union offers who knowingly participated in an illegal strike, and 2. Any worker of union offers who knowingly participation of illegal act during a strike may be declared to have lost their employment status. An ordinary striking worker cannot be terminated for mere participation in an illegal strike. There must be proof that he committed illegal act during a strike. Who declares the loss of employment status? The law ground the lawyer that the employer the option of declaring loss of employment loss status. Next, financial assistance to dismissed strikers. Financial assistance is not required to be giving to a worker who participated in an illegal strike. Strike on good faith belief that company committed unfair labor practice. Strikers who conducted an illegal strike on the good faith belief that the company had committed unfair labor practice, which turns out to be false, do not forfeit employment. They are entitled to reinstatement. Next, strike not make with good faith. Strike who conducted a strike which are illegal and not make with good faith forfeit their employment. Application of the pari delicto. Pari delicto is applicable in strike and lockout. Yes, when the parties are in pari delicto, the employees having staged an illegal strike and the employer having declared an illegal lockout. Such situation warrants the restoration of the status quo ante the bringing back the parties to the perspective position before the illegal strike and illegal lockout to reinstatement without backwage of the damages employees. Is backwage. Backwage is economic strike. The strike are not entitled to backwage on the principle that a fair day wage cures only for a fair day's labor. Unfair labor practice strike, the rights of the worker to receive back pay depends on with next employer right to hire replacement during strike. The discussion of principle giving hearing of working replacement during a strike. During pendency of an economic strike, the employer may hire a replacement on a permanent basis and it's not bound to discharge such permanent replacement in the event that the strike decide to resume their employment. On the other hand, while replacement may also be hired by an employer to take the place left vacant by employees engaged in unfair labor practice strike. The replacement are not permanent in the employer under a duty to dismiss them as soon as the strikers requires remain in their previous position. Damage offers may not be vicariously held liable for illegal act or striker the role of vicarious liability no longer appeals. That's all.